The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials. But on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach. And I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
And with Uverse, you can move your TV anywhere in the house.
We're happy with Xfinity. Why would we move the TV?
I don't know, but let me show you. Now, if you had the Uverse wireless receiver, you could take this anywhere. See? Anywhere you want.
Don't settle for Uverse. Get the most entertainment on any device anywhere with Xfinity from Comcast.
What if there was no car legal hotline? Just one call to a lawyer would cost you at least $250 per hour. What if you only had unreliable or hard to understand industry reports to include in your business plans and share with your consumers? What if there was not an organized association to fight for your right to conduct business in a fair and equitable manner and to protect consumers' private property rights? What if CAR never changes with the times to meet our members' needs? You don't have to ask what if anymore, because over the last 18 months, CAR expanded the Legal Hotline 2 more hours a week to help answer your legal questions. CAR created a research program that provides Colorado realtors with accurate and reliable quarterly housing market reports. CAR successfully advocates on Capitol Hill each year on behalf of all Colorado realtors and private property owners, so you can focus on your business. CAR created a professional development program that focuses on timely and relevant real estate issues through our live webcast program. CAR established relationships with many real estate-related companies to give you member discounts on things you actually use and need to be successful. CAR produced phenomenal networking and professional development opportunities in 2013 through its meetings and events. CAR's quest to make your state association better, stronger, more relevant, and able to withstand future challenges of the real estate industry is a never-ending journey. We have successfully put many solid processes, programs, and services in place. Now it's time to take the next steps of our journey by adding more value to your membership. Our vision is to create more opportunities for Colorado realtors to lower their risk by expanding the hours of the CAR Legal Hotline. Provide more reliable industry and consumer data to make you more confident and productive in the sales process. Produce even more live webcasts you can apply to your ever-changing business and help you remain on top of your game. Build a deeper political war chest to help preserve the industry and protect your consumers' rights. Increase our outreach to our local realtor associations, MLSs, and members. Take advantage of your CAR benefits and features. Visit coloradorealtors.com for details.
Who wants more peas?
Go away.
Oh, Daddy hates pop-up ads. Who wants
Go
more?
away.
Hashtag dinner time.
Let's go forward.
Choose selfie. No. Selfie.
Let's go forward.
Delete selfie.
Go away.
Then picture.
Bookmark. Go away.
No, post photo.
Scroll up. Scroll forward.
Hashtag gravy.
Faster. Go faster.
The First Bank mobile app. Technology has never been so easy.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
Good morning. I'm Wes Parham, Director of Business and Professional Development for the Colorado Association of Realtors, and I want to thank you so much for joining us today. The purpose of today's webcast is to present legal topics and issues that we address frequently at the association. Our panel is also going to take some time to answer your questions that you've given us as well, and I'm looking forward to introducing Steve Morgan, who serves as General Counsel to CAR and will serve as the moderator this morning. But first, I wanted to pass along a special thank you to First American Title for their support in presenting our webcast program, which, as you know, is part of our professional development initiative here at the association. I'd like to give them just a few minutes to catch you up to speed on some of what they're working on.
Hello, I'm Ryan Martin.
And I'm Debbie Myers, Business Development Representative with First American Title, Northern Colorado.
Our Northern Colorado team is comprised of seasoned professionals averaging 15 years in the business.
Our team chose First American because of the longevity and stability of the company, combined with their fresh approach to the business and focus on employees and clients.
Today, we'd like to introduce to you an exclusive First American tool, My First AM, or My MFA for short. MFA is a web-based program as well as a mobile application.
Let's face it, the array of tools today can be overwhelming. So we'd like to highlight a few of the features that you, the real estate professional, can use out in the field.
With a few clicks, I can answer questions for a buyer that the MLS printout doesn't have. What did the seller pay for the property? When did they buy it? What do they owe? Who are the neighbors? What are the school districts? FSBO comps? Not only can I answer these questions, I can email a report right then and there.
There may be times you need information after hours or even on the weekend. Now you can access most all counties in one place. Pull the property details, review transaction history, and in most areas actually see the copies of the recorded documents back 10 years. Things like vesting deeds, deeds of trust, all the other liens against the property.
Contact your local First American representative to get you set up today. Thank you for your time today and enjoy the webcast.
And thanks again to First American for your continued support. Now, I have a few quick housekeeping items before we get started this morning. We've allocated an hour and a half for today's presentation with a 5-minute break scheduled at or just before 9:30. If you have any questions along the way, please feel free to type those in according to the instructions there on your screen. What we do is we collect those. We'll review them during the break and have Steve and our panel address as many as they can when we come back. And finally, a link to full bios on our panel and information on the CAR Legal Hotline can be found in the area below the video screen that you're watching right now. If you have any questions or problems accessing those, please just send a note to the email address there in front of you. So with that, our moderator is Steve Morgan. Steve is the Chief Operating Officer and General Counsel for the Colorado Association of Realtors. He oversees the Legal Hotline, and he also speaks frequently to local realtor associations and industry groups on a variety of real estate and legal topics. Steve brings more than 20 years of experience to the association with a background in business and real estate law, and at this time, I'll turn the program over to him.
Thanks, Wes. Good morning.
I'm Steve Morgan, as Wes said, General Counsel for the Colorado Association of Realtors, and I want to thank you for joining us this morning. As Wes mentioned, the purpose of today's webcast is to update you on several issues that we see frequently, but more importantly, we're looking forward to answering your questions that you'll be providing us throughout the webcast. We've received quite a few already, and we'll be jumping into those in a little bit, but before we do, I'd like to introduce our panel here this morning. First, to my left is Scott Peterson. Scott is a commercial real estate broker where he's an active member of the Denver Metro Commercial Association of Realtors. He is also a member of the CAR State Legislative Policy Committee. Scott is a licensed attorney and also assists me with the CAR Legal Hotline. In addition to maintaining an active law practice, he represents individuals and businesses in real estate, business, and estate planning transactions. Our second panelist this morning to my right is Don Eby. Don is the lead attorney for the real estate division of Robinson and Henry PC, where he is an advisor on both commercial and residential issues, real estate financing issues, land development and zoning, as well as property management and HOA disputes. Prior to practicing law, Don owned and operated a real estate company and served as an officer in the U.S. Navy. Scott spends a lot of time helping me with the CAR Legal Hotline, and we get a lot of questions frequently that seem to become topical. And so before we get going this morning, what I want to do is have Scott talk to you a little bit about real estate financing issues and what's going on with the Dodd-Frank Act. There's a lot of questions that we get on the legal hotline, a lot of confusion with respect to seller financing. So we're going to start off by letting Scott address some of those issues. Scott?
Thank you, Steve.
You bet.
So one of the things one of the issues that come up frequently in answering hotline calls from realtors around the state is the changes that really kicked in at the beginning of this year related to seller financing or owner carry since the full implementation of the Dodd-Frank Act. There is a lot of confusion about what brokers can and can't do. And I just want to address kind of what the act is, what it does, what you can do, and what you shouldn't be doing. So just a little light comic here. This is no one will know until this is actually in place how it actually works with financial reform. I think everybody would agree that it's something was needed to address some of the lending practices previously, and I think by and large the implementation has been pretty good, and hope it continues to improve and go down that road. So the Dodd-Frank Wall Street Reform and Consumer Protection Act, commonly known as Dodd-Frank, it was the federal government's response to our recent mortgage and financial crisis. Dodd-Frank created the Consumer Financial Protection Bureau, the CFPB, and the CFPB now is responsible for oversight of the financial services industry, which would include banks, credit unions, debt collectors, title companies, securities firms, and mortgage originators. And so a mortgage originator is anyone who performs activities related to the origination of a residential mortgage loan. That would include offering or negotiating terms of a residential mortgage loan. And in the case of a seller carry transaction, the mortgage loan originator would be the seller. And that's an important distinction. It's not the broker, which is what I get a lot of questions about. And so there's some exceptions, but I'll get into those in just a minute. This applies to any residential property, and that would be a dwelling that has a dwelling on it, a structure with between 1 and 4 units, and the loan is secured by a security interest or a mortgage in that property. Mortgage loan originators must be registered with the CFPB, the Consumer Financial Protection Bureau, and the loan must meet certain minimum CFPB requirements. This generally does not apply to non-residential loans for commercial land, investment properties, etc. So it applies to the vast majority of people, of realtors that are doing business out there, and the transactions that they're working on. So who is exempt? And very generally speaking, and subject to certain loan structure requirements, Sellers are not considered a loan originator if they provide financing for 3 or less properties in any 12-month period, and they own the property securing the financing, and they are not a builder or developer of the property, and the loan itself meets certain requirements. I give this more for informational purposes because I think it's important that realtors not be advising clients as to whether or not they fall within the exemptions to being a registered mortgage originator. But it gives at least you guys some background in terms of who that might apply to. So the 3 or less property requirement is something that has created some confusion within it. So it's 3 or less properties in a 12-month period. And a lot of the calls that I get, or a lot of the queries that I get related to this is, an agent will say, or a realtor will say, gee, I've done 2 seller finance transactions this year. Is it true that I can only do 1 more? Or I've done 3 and I can't. Can I not take any more of that business? And the answer is no. I mean, as an agent, you're allowed to work on as many seller finance transactions as you want. That 3 or less requirement applies to the seller, in this case, the person that's taking the note back or carrying back the mortgage on the home. So the other thing that is helpful, I think, that the commission did is they changed the contract. As all of you will recall, the contract used to have a long section with respect to carryback financing that would essentially be maybe not an application, but it would be almost a negotiation for interest rates, the carryback terms, length of the mortgage, amortization period, and so forth. And the commission removed that in paragraph 4.7 of the contract. So now there's a nice kind of bolded warning there that to the parties that they probably ought to consult an attorney or a registered mortgage loan originator if seller financing is involved. And so I think it's a helpful paragraph there for you all as you have your preliminary discussions with your clients. But regardless, the situation, in my opinion, sort of puts brokers in a bit of an awkward position. So what can what can't realtors do? And there's really only 2 things that as an agent or a broker you can't do. You cannot take a residential mortgage loan application, and that's I guess generally construed. You certainly don't want to be receiving credit information from a buyer for the seller. For the seller's processing. You don't want to be negotiating any of the terms of the loan or taking an offer to loan or an offer to carry back from a buyer and sort of giving that to passing that along to the seller. And so you've got to be very careful when you get into that part of the transaction on an owner carry deal. And then the other thing that you absolutely can't do is negotiate the terms of a residential mortgage loan. So, you can negotiate every other aspect of a contract, every other aspect of the transaction, but when it comes to an owner financed deal, you can't be the one in the middle that's saying, hey, my seller he'll do a 5-year carry, at 6% interest or whatever. You just can't be put in the middle of that. And so that gets to where I say it puts brokers into an awkward position within the transaction, because a lot of your clients expect that you're going to be, that's what they're paying you for, or you'll be receiving your commission for, is that kind of advice. And so I think what you should do in order to head that off is prepare your seller at the time of taking the listing. And in the event of a potential seller carry transaction, and usually that's something that a seller is going to say up front, that they're either willing or able to carry back a loan, or they'd be very excited to carry back a loan on the sale of the property. I kind of came up with some language that you can put into the additional provisions of your listing contract here. The appearance of the language is not necessarily critical, but having this conversation is at an early point is critical, so that you're setting your client's expectations with what you're precluded from doing in the course of a transaction. And so I think that the earlier you do that in the transaction, the better, so that you don't have a frustrated seller at a point in time where you guys are getting down to deal points and trying to put a transaction together, and the seller feels like you've kind of stepped away from the thing. Again, I refer to paragraph 4.7 of the purchase contract, and I mean this even at the listing period. This is a document that you're going to go over with the seller, because it's something ultimately they're going to be signing when you do find a buyer for the property. And that paragraph 4.7 and the warning contained therein, I think will, it'll help you initiate that conversation that they ought to be consulting very early in the process, and I mean before contract, an attorney or a licensed mortgage loan originator to prepare the documents and really handle the seller financing piece of the transaction. And then if the seller financing comes up at a later point in time, I would obviously point them to an attorney or mortgage loan originator, and then you've got to force them to carry on any loan negotiations directly with the other party. And this is kind of the challenging part, in my opinion, because every realtor doesn't want to lose control of a transaction, and the restrictions here kind of force you to push your seller and the buyer, the two clients, directly together to carry on negotiations related to the transaction that you in normal course of business would be a part of. And so one of the things that I tell people to call in, and I think that makes sense to me, is to kind of start an email chain, basically, and without being involved in the negotiations, ask the seller and the buyer, they're copied on the same email along with the buyer's agent, to carry on discussions over the course of the email, so that everybody sees and can make sure that the agents are in the loop, but they're not actively taking part in the negotiations or taking any part in the negotiations, but they're not losing control of the deal, which I think is everybody's kind of concern as an agent. So those are my thoughts on kind of how realtors in this world are now dealing with some of the restrictions on Dodd-Frank, and hopefully that's a helpful summary of where we've come from and how to address the concerns that many of you seem to have out there.
Thanks, Scott. That's some great advice. And as Scott said, certainly if you've got clients that are involved in seller financing, the best way to deal with it is up front, ahead of time, and let those clients know more than likely they're going to have to get a mortgage loan originator and attorney involved, probably in the transaction. So with that, I'd like to turn to Don. Don has got a lot of expertise and experience in real estate property management as well as landlord-tenant issues. And so I'd like him to bring you up to date a little bit about what he's seeing out there in the market right now. Don?
Great. Thanks. Thank you, Steve. I appreciate being asked to be here. I'm excited to be here to speak with the realtors. And obviously, Scott, that was a great presentation there. Certainly, seller financing is a hot topic that we see throughout the marketplace. I want to touch in my introduction on really three primary issues that I hear and see a lot about. Maybe seed some questions. I know that most of you out there in the audience really are interested in the questions that you want answered, so I won't spend a tremendous amount of time here getting started. But what I see brokers and property managers having the biggest issue with is their upfront agreement with their owner, the property owner that they are representing. Now, brokers and property managers that are representing apartment complexes, they usually don't have such a problem, but those that are representing individual owners tend to get themselves in hot water with this. And I think that I think that you out there, as you're working, you have to remember that you're working for the owner as you're representing this property. And even though many times the communication and most of the dealings is done with the tenant, it still goes back to your relationship with the owner. So you really need to get a solid agreement and a contract set forward, establishing the rules of the road and establishing the rules of the game that you'll play by during the course of this representation. Lay out the relationship, lay out the obligations, make clear the limits of your responsibility and your roles in how you're going to represent them in this property management scenario. Many times I see brokers, property managers get in trouble, over-promising and leaving landlords or owners to expect that the property manager is going to go out and inspect the property, do a walkthrough on a monthly basis, and force the tenants to live and live in the property and care for it in the same way they would as the owner. And that will get us into problems often. So, for example, if you were a property manager and an owner left personal property in the home, let's say, for example, they left a valuable stereo, or they leave washer and dryers in the home that are personal property, probably you would need to get that into your upfront agreement with the owner of who's going to be responsible for that. Say, for example, it's not unusual that the tenant leaves and takes that property with them, and guess who the owner is upset with and thinks that they failed in their duties. Obviously, you're the easy target for them to find. The tenant is difficult to find, to actually collect from, and the broker is always available. So be careful and make sure that you delineate out these issues. Discuss in your property management agreement with the owners how you're going to terminate the agreement and what will happen if you terminate the agreement. How you'll handle the security deposit, moving it forward, giving it over, returning it to the owner, making sure that the tenant is advised that that security deposit has been transferred to the owner. Probably lay out in that property management agreement some limits of liability. How can you protect yourself? Think of how you can protect yourself in this problem, and always think about what's going to happen at the end of the day and how things might go wrong, and how the landlord or owner is going to be looking to you as the person that they might be able to find whenever they have significant damages from a flood that's occurred in their home, that maybe the tenant was ultimately responsible for, but the landlord wants to hold the broker or the property manager responsible for. So think about that. I urge you to have a very clear and definitive property management agreement with the owners. The second issue or topic that I see often is security deposit disputes. Still, there are ongoing property issues with security deposits. The issue with security deposit is the Security Deposit Act, Security Deposit Statute, is really the one place where tenants have the leverage, where the one place where the tenants have the upper hand in this landlord-tenant agreement. So landlords, property managers have to be very certain that they're complying with the Act. The Act requires that the security deposit is returned to the tenant or an accounting thereof within 30 days unless the lease extends it to 60. Now it's seldom to see a lease that doesn't address this and extend the term to 60, but nevertheless you have to make sure that your lease does extend that term to 60 days. Whenever the problem that most often occurs in these security deposit issues is, when does the clock begin to run? The statute says it's 30 to 60 days from the return of the property or the termination of the lease. So if you have a term lease where the lease ends on July 31st and the tenant moves out on July 31st, in that case you have a very clear termination and ending of the lease. But where people get into trouble is, what if you have a tenant that abandons during the middle of the lease, and you as the property manager didn't give authorization or terminate the lease? When is that lease actually terminated, and how long can we press this time limit before our 30 to 60 days begins? Tenants oftentimes will assume that it begins immediately upon the return of possession, and they'll send a 7-day demand letter, but their demand letter oftentimes will be premature in these cases. So pay special attention to that. The issue there is always get that, as soon as you can get the accounting out, go ahead and do so. If you have significant damages, get those damages as complete as possible before you send that security deposit accounting letter out, so that you're not limiting yourself if you decide, or an owner decides to go after damages to the amount of just the security deposit. If for some reason the security deposit accounting letter is not sent, and the time has expired, and a 7-day demand letter is issued, at that point, the only way that you can protect yourself and your owner is to actually return the security deposit. That doesn't mean that you can't collect on a claim for money damages if there were indeed actual damages beyond normal wear and tear. But it does mean that if you didn't comply with the statute by supplying the letter, you now actually have no right to retain the security deposit. So many attorneys are quite versed in this, and you should contact someone if you have any questions relating to security deposit. I see these oftentimes, and there's a lot of confusion out there about how that will work out. The last topic I'd like to just touch on briefly, which I see a lot of confusion in the marketplace, is how is marijuana and or medical marijuana handled in the landlord-tenant relationship? Must a landlord require or allow a tenant to have or grow or use medical marijuana, especially in the sense of if they have a medical marijuana card? The answer there is that the statute doesn't require landlords to do so. It is still a federal offense. Landlords have significant risk in allowing tenants to grow, possess, and use marijuana in their homes. Property can be seized. So there's a lot of risk there, and I think if you do not have a specific clause in your lease that addresses marijuana in general, you definitely need to get that lease revised and address that specific subject. It's becoming more and more hot. I see more and more confrontations about that. Many people have tried to rely on just a general clause of illegality, using the property within normal legal means, and that's a general clause, will work in most cases. But as a professional property manager, your lease probably should be more precise, deal with the issue of marijuana growth, medical marijuana particularly. So I know you have a lot of questions out there and you want us to move on. Maybe those topics are things that you would like to hear more about, and if you have specific questions, I'd be happy to address those. Steve?
Thank you, Don. Yeah, I'm sure we'll get a lot of questions related to landlord-tenant issues. In a moment, we're going to take a brief break, about a 5-minute break, where you can go ahead and send in your questions. We've already had questions coming in this morning. But what we'd like to do, obviously, is spend the majority of our time answering your questions. Before I kick it to Wes, one of the topics I want to address briefly that I've been getting more and more questions frequently on, deal with the post-closing occupancy agreement. It's a new form that the Commission promulgated about a year ago that's being used more often. And one of the questions we had come in was, if an offer is submitted with a different possession date than the closing date and accepted, but no post-closing occupancy agreement is submitted with the offer, can the buyer's agent submit an agreement after the contract has been executed? What happens if either the agent does so after the contract is executed and inputs a rental amount and or terms that are not satisfactory to both parties? Certainly this can be problematic. If you go under contract and you've got a different possession date than the closing date and the parties haven't addressed that, and now they're going to attempt to negotiate the terms of a post-closing occupancy agreement, good question. What happens if they can't come to some type of an agreement on that post-closing occupancy agreement? What effect is that going to have on your contract? More importantly, within that agreement, as you can imagine, when a buyer buys a property and closes, even though he might not get possession for a certain period of time, it's his property. So there are insurance issues and other issues that need to be addressed. But I would advise that if the parties are contemplating giving possession at a date that's later than the closing, then certainly the post-closing occupancy agreement should be part of the initial offer that the buyer is making. So a lot of times, obviously, the buyer doesn't know that the seller wants to change the possession date, and that'll come back in the form of a counter. If you're representing a seller and you counter an offer because you want to take possession a certain period of time after the closing date, then it would certainly be appropriate, again, to include that post-closing occupancy agreement
so the parties can negotiate those terms at the same time they're negotiating the terms of the sale as well. So with that, I'm going to kick it back to Wes here, and we're going to take about a 5-minute break. We'll gather your questions, and we'll be back to answer those questions in just a few minutes. All right? Thank you, guys.
All right, thanks, Steve. So with that, we're going to take a 5-minute break. The purpose for this break is to give you an opportunity to send us any questions that you might have. When we return, Steve and the panel will address as many as time will allow. We'll see you in about 5 minutes.
And with Uverse, you can move your TV anywhere in the house.
We're happy with Xfinity. Why would we move the TV?
I don't know, but let me show you. Now, if you had the Uverse wireless receiver, you could take this anywhere. See? Anywhere you want.
Don't settle for Uverse. Get the most entertainment on any device anywhere with Xfinity from Comcast.
Who wants more peas?
Go away.
Oh, Daddy hates pop-up ads. Who wants
Go
more?
away.
Hashtag dinner time.
Scroll forward.
Choose selfie. No. Selfie.
Go forward.
Delete selfie.
Go away.
Send picture.
Bookmark. Go away.
No, post photo.
Scroll up. Scroll forward.
Hashtag gravy.
Faster. Go faster.
The First Bank mobile app. Technology has never been so easy.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials, but on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach, and I really appreciate that, and they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30-plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.
Thank you, and welcome back. We got a lot of great questions, so we'll get right to them. First, Scott, let me start with you regarding earnest money. Is it mandatory to submit either earnest money or a promissory note with an offer and a contract? For example, in the case of a cash deal that's going to close a week later, for example. So why don't you speak to just the earnest money in general, Scott?
Sure. Yeah. No. I think there's maybe some real estate custom that a copy of a check or a check will be delivered with a contract, but that doesn't. It's not certainly not required to create a valid contract. In most cases, there's an alternative earnest money deadline that's inserted into the contract, and that's what dictates the deadline for the date of that delivery. So no, it's not required. Whether it's a cash deal or not, it doesn't matter whether there's a loan or it's a cash deal. It's still the same thing would apply. So yeah, no, definitely not necessary. If there is not an alternative earnest money deadline, then I would say that earnest money is due upon mutual execution of the contract. So there probably would need to be some coordination if you're not filling in the alternative earnest money deadline blank in the contract, which I would encourage you to, just so that it's clear to everybody and it gives everybody a little bit of breathing room. But if for some reason that's not filled in at the time of that the offer is presented, then you'll need to coordinate and get earnest money delivered at mutual execution, or when the seller accepts the contract.
And I guess one of the things I'd add, Scott, is keep in mind that earnest money is not required in a contract. So a buyer can submit an offer that doesn't have any earnest money required at all, whether it's an alternative earnest money deadline or with the contract. Certainly the seller could counter and ask for earnest money, but there is no requirement, just so you're clear, there's no requirement that you have earnest money to make a contract binding.
Yeah, that's true, but it is, I guess, important is to note that if there's no earnest money in a contract, there's no recourse whatsoever for the seller, because the earnest money is the exclusive.
Is the liquidated damages.
Exactly.
Correct. Anything to add on that, Courtney?
So it's the custom that's probably causing
Absolutely.
the confusion here in the marketplace. Is the custom of earnest money is being confused with the legal requirement of earnest money, is what I'm hearing.
Corky, with respect to property management, we have a question regarding if a landlord leases a residence to an LLC, how should the lease be written to hold the LLC members personally responsible for the rent and the obligations on the lease?
This is actually a very common scenario in the world of small business leases. Many times a landowner of a small strip mall or something of that nature will want to lease to an LLC, but they want to have a personal guarantee, and they want the owner of the business or the managing member of the business to be personally responsible for the contract. And I think that's what's being asked here. Essentially, it's very simple. You can lease to an LLC. You can lease to an LLC and the member individually, personally, or you can just lease to the LLC and then have the owner or manager of the LLC personally guarantee the lease in the signature line. So in that way, you would have the owner sign the lease, as managing member, and then maybe a second signature or just an annotation below the signature of "and personally." And that way, if there's damages, beyond the security deposit at the end of the lease, or the LLC breaches the lease and abandons the property, and the landlord wants to go after the individual individually because the LLC essentially has no assets, then they'll be able to do that. And they can do that in a business scenario or in a residential scenario.
Yeah, and I would say that it's really important if you're doing business with an entity, an LLC or any entity for that matter, that one of two things happens if you're a property owner, either or a property manager and representing a property owner. Either the entity that you're doing business with has extensive assets and an operating history and something that's tangible that they're not going to necessarily walk away from, or you're going to get a personal guarantee, because other than that, there's no recourse for a landlord. And I see so many times disputes, small kind of mom and pop, particularly commercial landlords, because that's the tenant type that generally will use an entity for their business. they enter into these leases, and then they contact me to say, hey, these guys have split, they've left in the middle of their term, what can I do? And in the event that it's not executed, or it hasn't been executed or guaranteed personally by the individual, and oftentimes that doesn't matter either if it's somebody that's really kind of a deadbeat, then there may not be much to chase anyhow. But if you don't have some sort of personal guarantee, you're stuck chasing an entity that at that point likely has very, very little in the way of assets.
Yeah, and I would certainly agree, Scott. Anytime you're dealing with an entity, it's going to be important to look kind of behind the curtain, so to speak, and see the history of that entity and what kind of assets it has and things like that, so that you can make your client aware that a personal guarantee may be necessary. However, I'd also caution you, you certainly don't want to be drafting guarantees for your clients. So it's something that you'd probably want to engage an attorney to draft a guarantee document that you would have those individuals sign versus just trying to attach it onto your lease. Scott, coming back to seller financing, we have a question. How can you offer seller financing without any mention of the terms, like down payment, rate, length of term, things like that?
Well, you've got to be careful. If you're gonna, you can offer it. I mean, there's a difference between saying my client is willing to do X, and that's it. That's not negotiation. I think you've got to be very, very careful, though, as an agent in even going down that road, offering or negotiating the terms of a carryback loan is what's precluded. And so if there's no negotiation, if somebody's putting in their marketing material as an example, the seller is willing to do X, and any deviation from that has to be carried on between the parties directly or through a mortgage loan originator or licensed attorney, then that's going to be the only way that you can have much discussion on it. Again, as I alluded to in my earlier piece, the whole topic, I believe, really puts brokers in a bit of a awkward position with respect to their clients, and that's why having that conversation and really making sure your client understands what you can and can't do at the inception of your listing agreement, rather than at the time of contract, is going to be helpful, I think. And there's lots of material to support anything you'd be telling them in terms of what you're precluded from doing. But you just have to be very, very careful. And I think the other thing I'd add is that how the commission is going to oversee this is this is all kind of new, and so we're in a bit of an emerging area here as the year has turned over. And to my knowledge, I don't know that there's been, other than position statements, there have been any actions by the Real Estate Commission with respect to a broker doing this. I would also remind you that if things go wrong in, and this was part of a Real Estate Commission position statement, if a broker gets involved in a seller finance transaction and sort of goes beyond what they're allowed to do as an agent, if things go wrong with that carryback loan, the errors and omission insurance isn't going to protect you because it's outside of the scope of what you're allowed to do. And I think it really presents some potential liability for brokers that are getting carried away with what they're doing or acting in violation of what's been mandated that they do. So just be careful if you're dealing with owner carry. Push your client to an attorney or to a registered mortgage loan originator is the short of the advice.
Scott, have any of your clients gotten you involved in these yet on negotiating seller carry terms?
Yeah, I mean, I've done some, for years I've done some loan, preparing loan documents and that kind of thing. I think that was another part of the question that they alluded to was, you can find forms for deeds of trust and promissory notes, and those, kind of loan documents are readily available. Stay away from them. I mean, it's a mistake. You're going to get yourself in trouble if you get, as a non-attorney, you're going to get yourself in trouble if you do too much of that stuff. Even though you're working off of a form, even though realtors are bright individuals that wouldn't be successful in the business if they couldn't handle that stuff. It really goes outside of the bounds of your practice area, and you run the risk of getting in trouble with the Real Estate Commission, getting in trouble with your errors and omission insurer. And you create liability for yourself that your clients really don't have, in my opinion, a right to impose on you and ask you to do.
And I guess I would add one last thing. Keep in mind, if it's something that you do a lot of, or if you're in one of those markets where your clients are doing a lot of seller financing, one other option is to go get licensed as a mortgage loan originator. So you could also go get that license and hold that as a separate license, which would allow you to then be involved in those seller negotiations. Don, coming back to a property management question, one of our viewers asks, I'm employed as a property manager and would like to start showing properties for others not affiliated with our company and be paid to me or a company I plan to start. I know I can't practice real estate outside of what I do for my employer, but showing is not practicing real estate. You might comment on that. Are there any other problems that might arise from this service? Why don't you speak, Don, a little bit to when you have a real estate license, what you're allowed to do with it when within one company versus doing things on your own?
Yeah, it sounds like a pretty risky area that someone's considering getting into. Employed by one company and then wanting to work and show property outside of that agreement. And probably I would advise that broker not to skirt that fine line of what really is practicing, acting as an agent, acting as a broker in the employment of their license when they're talking about showing property is not a portion of, is not acting as a broker. I suspect that that employer would not see the situation that way. And if there's a commission that the employer does not receive based on that action, probably they'll be coming back looking strictly at that broker. So, would you like to add anything?
No, I think that covers it. Again, when you've got a license with one company, everything has to go through that brokerage firm with respect to brokerage services. So while you might contend that showing properties in and of itself isn't practicing real estate, I think that if you look at the statute and how it defines brokerage activity, that certainly might fall within that. Scott, regarding the appraisal deadline, we have a question. What is the reason for the appraisal deadline? It would seem to have no consequence as long as the appraisal is received before the appraisal objection deadline. I think you'll find the answer interesting.
Well, I wonder the same thing myself. I mean, I think it creates a bit of confusion for people, but I just, to my mind, I agree. I mean, I think it maybe gets the buyer off the dime. I mean, it forces them to engage somebody and get somebody through the house at a certain, by a date certain. But in terms of, the operative date really is the appraisal objection deadline. But yeah, when you've got an appraisal deadline in there, you could always leave it out. You could not insert an appraisal deadline and just have the appraisal objection deadline if it really bothered you. But it forces people to have a date certain by which a licensed appraiser is going to get in and make an appraisal on the property.
Yeah, I'd agree with you.
There really isn't necessarily a need for it, but
yeah, and it's probably there because in order to have an appraisal objection deadline, there probably needs to be an appraisal deadline.
Sure.
Because then you'd have questions saying, well, there's no deadline for the appraisal, so when does it have to be done? So I think they kind of go together. Don, coming back to property management and a marijuana question, can a tenant be prohibited from growing, consuming, or possessing marijuana in the lease agreement on the grounds, since marijuana is still a federal offense, that could result in the seizure of the landlord's home? Medical marijuana would only be allowed as long as a written copy of the prescription is on file, and then no smoking would be allowed in the property. And I know, Scott, certainly you have thoughts on this topic as well, but Don, what are your thoughts on that?
Yeah, absolutely. A tenant can be prohibited even if they have a medical marijuana card. The statute is very clear in the original passage of the Medical Marijuana Act that landlords still have the ability to prevent a tenant from growing, possessing, or using marijuana in the property. So, and the reason for that is, I think, very clear, is that the landlord undergoes significant risk by allowing a tenant to have marijuana, an illegal substance under the federal laws. That home or property, apartment complex, the property, real estate can be seized by the feds if they so choose. The federal government has said that they will essentially, ignore this as long as tenants or property owners aren't flagrantly in violation. But we have seen examples in Colorado where individuals that were growing marijuana legally under the Colorado statutes, the home was seized by the federal authorities because of the manner and the amount in which they were operating. So definitely landlord has the ability to protect their property, and in protecting they can prevent the use or possession or growth of marijuana, even medical marijuana.
Yeah, and I think one of the things that I would add with respect to this, certainly in a new lease, you could put language into that lease restricting what your tenant can or can't do. But for example, what if you're in the 5th year of a 10-year lease right now? And so this wasn't contemplated 5 years ago when you entered into this lease. As far as I know, Scott, almost every lease I've ever seen also prohibits illegal activity on the property. It's a broad generic statement that just prohibits illegal activity, but certainly anything involving marijuana would be considered illegal activity at the federal level.
Yeah, no, I would agree. I mean, Don alluded earlier that it's not necessarily, I mean, that at this point in time, if you're entering into a lease with a tenant as a landlord, a new lease, I would encourage you to have specific provisions that address both medical and recreational marijuana and the two amendments that constitutional amendments that brought those about. It makes sense to specifically address it, but in lieu of that, if you don't have if you've got an older lease that was executed prior to the passage of both of the amendments, then you could rely as a landlord on the quote unquote prohibition against illegal activities on the property. And this might come up later, but there's a lot of concerns with respect, in my opinion, to having that, in addition to what Don alluded to on federal seizure of the property. More importantly, most of your loan covenants have prohibitions against you or your tenants conducting illegal activities on the property. Your insurance underwriting typically has prohibitions or excludes casualty related to illegal activities. And so all of that stuff over the course, I think, of the next several years is going to kind of have an opportunity to work itself through some judicial interpretation, and it'll be interesting to see how it comes out. One of the things that Don and I briefly talked about earlier, and I think it might be an interesting shakeout, is with respect to medical marijuana and whether or not under the ADA or some protected class argument, somebody does have a right to use medical marijuana within a property. I would agree that it can be excluded, maybe even just through a smoking provision or no smoking provision, but we've seen that the form that marijuana takes and how people are ingesting it, is changed, and there's edibles and other kinds of ways that people can ingest marijuana. So it'll be interesting to see. I think Colorado is the leader on this issue, and will continue to be, even as we see other states entertain both. I think in this election coming up, recreational and certainly medical marijuana in a number of states. So.
While we're on this topic, Scott, and for those of you that are interested in this subject matter, we actually did a webcast about 2 months ago, I think, specifically dealing with marijuana as it relates to real estate in Colorado. And you can go to the CAR website, and that's actually been logged, so you can actually go back and watch that if that's of more interest to you. But keep in mind that all it would take is a change in the attitude of the federal government or of a new administration that might come in 2016 that would really flip this industry upside down. And I know that one of the things you had mentioned, Scott, in the previous webcast that we had done was that both landlords and tenants may want to start to consider having provisions in their leases that would allow for a termination of the lease if, in fact, the administration changed its position or changed its stance on this issue, so that a landlord could, in fact, terminate the lease and get rid of a tenant versus, subjecting his property to seizure.
Yeah, no, very important. I mean, it is a federal statement. It's a position statement of the Attorney General, the United States Attorney General at this point, that dictates the fact that the federal government is essentially willing to look the other way on this issue with Colorado and other states that pass these types of amendments. But if that, in other words, there hasn't been a congressional act or anything else that would change the federal government's position other than this statement, position statement. So it wouldn't take any constitutional amendments at the federal level. It wouldn't take any acts of Congress. It wouldn't take anything other than a revocation of that federal statement to change the way the federal government looks at this. So I do think that the ability to terminate a lease in the event that something changes, and that gets to these provisions, with respect to to having leases with the provision would include something along the lines of allowing the landlord to unilaterally terminate the lease upon some very reasonable notice to the tenant in the event that the federal position changed on its enforcement of marijuana laws at the state level. And Don had a
Go ahead.
point to add there.
Just, I think you're right about this ability to cancel the lease based on a change in a position. Certainly the illegality clause in a lease is a very strong clause that needs to be in all leases. And in dealing with this specific subject, a specific clause dealing with marijuana in general, and those are important to make sure that are in all lease agreements. The thing that you bring up, Scott, about the ADA and maybe a case might be brought in the future to resolve this in a much broader level will be a very interesting case. But I don't think that any of our brokers or realtors out there want to be involved in that case. So I would advise you to stay away as best possible, because that'll be a long and expensive process there. But one other thing that as I get onto this marijuana subject is, I see a lot of properties and a lot of property owners coming back after some tenant has been involved in the business with significant damages to their property that are a direct result of the growth and use of marijuana. It's things like, unauthorized additions to the electrical system. It's changes to the heating and air conditioning system. It's mold that's created by the growth of the marijuana. It's the remediation that has to happen after the tenant leaves. And I can assure you that, very seldom do these tenants that are involved, do they leave and pay enough money in addition to their security deposit to remediate or to fix the damage. And it's very difficult to collect on them because of the way their assets are held. So it's really a tough position for landlords. I urge landlords to be very careful about it.
So a related question that we just had sent in is the landlord obligated to advise any potential tenant or future buyer of previous marijuana use on the property site? Will this be seen as an adverse material defect? We might have some divergence of opinion. I don't believe that disclosing the prior use of a tenant or a prior seller would constitute failure to disclose just because it was used. On the other hand, if you have a growth operation in a property where you may have some of these issues that Don just referred to, certainly you may need to disclose something, but keep in mind the law requires you to disclose adverse material defects on a property, and so if there aren't any, just the fact alone that someone had been smoking marijuana on that property, I don't think would rise to the level of obligating someone to disclose. Any thoughts? Or?
Yeah, I mean, I would agree with you.
Okay.
I think Don brings up good points. The damages that are caused by, the hydroponic systems, they can cause mold in the property, the electrical modifications that are made for the lights and that kind of thing. So if there are issues that are a result of unlicensed contractors performing work on the property, or things that the seller is aware of that would be disclosed regardless of their cause, they need to be disclosed. And so I think that's the same would apply for marijuana.
Yeah, I would agree. I think generally use is probably not going to create an adverse material defect, but if the home or the property has been used as a grow house, there is a likelihood that it can create an adverse material defect from a mold perspective easily and quickly. So you have to be careful about that, and I think this question is really going to come down to a case-by-case determination by the individual seller. Are they aware of an adverse material defect that they should disclose? If they should disclose it, then maybe it comes down to a business decision of making a disclosure that the use was there as far as we know, there's no damage that has been done and no need to remediate. And at least that gets the seller off the hook for damages coming up in the future, because, buyers come in and buy, and then they find problems and they start looking for who can, spend that $10,000 or $20,000 to remediate their home because they have mold. So you have to be careful about it.
Absolutely. And then one other area that I've seen come up where actually brokers get involved is people move into Colorado specifically to lease a property to create a grow operation. So I had someone contact me where they represented a tenant who moved to Colorado specifically to create a grow operation. However, the broker didn't know that at the time. So as they started working with them, they worked with them to lease a house, and they got the house under lease. And then the tenant decided that that's what his business was going to be, and then disclosed it later to both the broker and the landlord. The landlord wanted to prohibit it, so it became an issue. So certainly if you've got clients that you're leasing property to or for, you should inquire as to what their intended use is. And I would certainly suggest if you have a tenant that intends to create a grow operation in a house and thinks that he's going to do it without telling the landlord, that's going to be problematic for everyone. So while it's not required by law, it would certainly be a best practice to disclose your client's intended use before they either buy a property or, although I guess buying it wouldn't make as much difference, but certainly if they intend to lease a property. We also had a follow-up question with respect to earnest money, with a little confusion where the broker apparently was taught or told that earnest money is required to make a contract legal. And I think what they were getting at is you've probably heard that in order to have a binding contract, you have to have an offer, you have to have acceptance, and you have to have consideration. And a lot of time brokers are misconstrued thinking that the earnest money is actually the consideration in the contract, the thing of value that's being exchanged that would make the contract binding. And that's not necessarily the case. It's really the promise that the seller and the buyer are making to each other that is the consideration in the contract that makes the contract binding. So you could certainly have a contract between a buyer and a seller with no earnest money, but that contract would be binding. Now, as Don said earlier, it's not the practice, it's not the norm. The norm is earnest money in every deal, and certainly a seller is interested in that earnest money for the reasons that Scott said earlier, which is liquidated damages in case the buyer doesn't perform. But to be clear, earnest money is not required to have a binding contract. It is not the consideration in the contract.
Yeah, the consideration is the purchase price.
The obligation to buy and the obligation to sell.
Yeah.
Correct. Yeah. Along those lines, we have a question with respect to an amend extend, and I think that this member is confusing an amend extend with termination of a contract. The question is, if an amend extend is created but not signed by all the parties, is there another document then required to terminate the contract? What are the ramifications if the parties do not agree to the amend extend? Well, the first thing would be if they don't agree to the amend extend, then it doesn't take place and there is no amendment to the contract at all, and the contract is still in force as it existed. Same thing with the first part of the question. If it's not signed by all the parties, it has no effect. So just because one party signs an amendment and sends it to the other party, it's certainly not binding until it's executed and returned or delivered back. With respect to terminating the contract, a party doesn't need the other party's agreement to terminate the contract. So if a buyer sends a notice to the seller, and we have a separate promulgated form, which is a notice to terminate form that you could use. So you wouldn't necessarily need an amend extend unless the parties were mutually agreeing to terminate the contract. But if one party decides to terminate the contract, they can simply give notice to the other party in writing, and that notice is effective, and they don't need any signature on amend extend. Any thoughts on that, guys, at all?
I would just add is with the amend extend, I think that really the easy way and simple way for people to look at this is it's just like your original offer to purchase. It's an offer to change the terms of the contract. So until that offer is accepted, until that amend extend is signed by the opposing party, all you have is an offer. And if they don't accept it, then you've not changed the original terms of the contract by offering to do so. You can't
Thanks, Don.
force them to do that.
Correct, correct. And amend is like you said, it's just another offer, kind of like a counter offer, any other offer to change something. And so if the parties agree, it takes effect, and if they don't agree, it has no effect whatsoever. Scott, with respect to referral fees, we have a question. Can an organization, for example, like the Lions Club, be offered a referral fee for any real estate closings that occur as a result of a referral from the organization? I guess one of the things is I don't know that you'd necessarily get a referral from an organization. You would get it from a member of the organization, and they might want that fee to go to the organization versus themselves. Why don't you just touch a little bit on referral fees in general and how that works and who can receive them?
Yeah, well, referral fees need to be paid to licensed brokers. And so you have to be very, very careful. And it's a gray area. This is another area that I get a lot of calls on, frankly. I'm not sure if the Lions Club is a nonprofit or a charitable organization, but if it is, certainly you could advertise that, X% of your fees would go to a nonprofit if you were trying to, market yourself or be benevolent to a certain organization. That certainly would be allowed. But in terms of paying unlicensed people referral fees, it's not allowed. And so what you need...
Well, I'm going to disagree with you a little bit or qualify that.
Okay.
Because my understanding is that RESPA requires that a referral fee be paid to another licensed broker.
Mhm.
And so you'd have to have a license to receive a referral fee under RESPA. Now, keeping that in mind, RESPA really only applies to residential transactions where you've got government-regulated financing involved. So say, for example, if I was going to buy Corky's home for cash and someone referred me, my understanding is you could pay that person a referral fee because RESPA wouldn't apply to that transaction. Or a commercial transaction. If I referred you a client in a commercial transaction, you could pay me a referral fee even if I didn't have a license because that's not regulated by RESPA.
Sure.
Is that,
well, yeah.
okay. Now, granted, 99% of the transactions are residential transactions with finance.
And exactly, they're not cash deals, and they are 99% of the deals fall under RESPA.
Absolutely.
There are exceptions that I think probably specifically the two that you detailed. But generally speaking, I think our audience is doing transactions
But
under
I do
RESPA.
get questions where someone says it's a cash deal, can I get a referral fee?
Yeah.
And the answer would be yes, that you could, or it's a commercial deal.
Yes.
Okay, so again, you're right in the sense that most of our deals that we certainly see and deal with are residential transactions where they're borrowing money from a regulated lender.
Exactly.
But I didn't want it to be black and white that you could never pay a referral fee
Okay.
to anyone for anything, so. Go
Yeah,
ahead.
as a general rule,
Yes.
you can't be paying referral
Correct.
fees, but in the situations you're describing, you could. I think, so the gray area is, and what I tell people is, you have to be very, very careful. First of all, it can't appear on the settlement statement because it can't, it won't. So the difference would be, we live in a situation where I scratch your back, you scratch mine kind of thing, and you want to encourage people to continue sending you referrals. So I think you have to be careful how you structure it. It can't be an egregious sum of money. I think if you want to give a business gift to somebody for their benevolence to you, I think that's, again, you got to be a little bit careful and not have it appear to be or be a referral fee. In other words, I wouldn't want to cut somebody a check, an unlicensed person a check for, $7,283, and that happens to be 10% of the transaction fee. So you have to be careful about it, and that's, I think, the first issue. The second issue then, because of that, becomes some income tax reporting issues. I mean, it's a recognized gain on your income taxes because you're going to take the entire fee yourself. You're going to be giving something back out then. You can certainly do business gifts, and those are deductible and other ways. But there are ways that you can get caught up in this if you don't watch it. So you just need to be very careful about who you're distributing fees to if they're not licensed and the manner in which you're distributing them.
Yeah, I would urge all brokers to be very cautious with this because, it's a risk balancing issue in my view. If you're a broker, your livelihood depends on your license. The Real Estate Commission is going to look at this from a fee splitting perspective. So you're going to have to be very careful to ensure that it's not seen as a fee split.
Okay, next question.
Don, we've got several questions, so I'm going to try and combine these a little bit, but they deal with a broker's obligation and duties when they're a buyer or seller's agent as opposed to a transaction broker. And so questions like what can I say or not say as a transaction broker, and when do I switch, and things like that. So why don't you just talk briefly about the differences between transaction broker and a buyer seller's agent, and how a broker should handle that.
Yeah, let me just speak about that. That's an interesting question. It comes up often, and I think it is something that brokers have to be concerned with, especially if they're acting as a transaction broker. And really the bottom line golden rule here is if you're acting as a transaction broker, then you have no loyalties, no duty of loyalties to either side. And by no duties of loyalties, then you can't play partisan to one side or the other. So you have to be very careful about what information you share. Do you get involved in negotiations, acting as if you're representing one party or the other? So the transaction broker has to be very clear with both parties that they're merely, taking offers and delivering them to the other party. They're making no duties, they're not an agent for either party. They're not arguing for either party or helping them to process or get an agreement on the deal. So it works well, and a lot of agents use the transaction brokerage perspective, but it has to be used with caution.
Any thoughts, Scott?
Yeah, I would agree completely. I mean, it's the difference is that you don't have a fiduciary obligation, and if you do something for one party that you're not doing for the other party, then you could be crossing the line. So I think it's a bit of a difficult situation. I'm always surprised by the amount that transaction broker is actually used. I mean, I think generally speaking, the consumer, the buyer, the seller wants an advocate in most cases, and I see a lot of transaction brokerage deals, and I know there's functional reasons for it, but in cases where there's no real reason, in other words, you don't have two brokers from the same shop acting as an agent on either side, so they both have to default or something along those lines. To me, it doesn't. I think the proper relationship is an agency relationship. I mean, that's the one I would be at least the most comfortable with.
Yeah, my sense is that brokers think that by maybe acting as a transaction broker, there's less chance of them being held liable for something, or. But my sense would be that if there's negligence in the transaction in any form, relying on the fact that you were a transaction broker versus a buyer or seller's agent is probably not going to get very far. Yeah. I also see transaction brokers who, while they categorize themselves as a transaction broker, are actually acting as a buyer or seller's agent in the way they are advocating or the way they are negotiating.
Exactly.
So just by classifying yourself as a transaction broker in and of itself isn't going to remove you from liability for your actions to your client. So with that, Scott, pretty straightforward question. What are the legal ramifications to a buyer who does not send an executed inspection resolution to his lender?
Well, yeah, this has been another upshot of kind of some of our mortgage crisis stuff and the difficulty in loan underwriting, or say difficulty, but the additional requirements associated with loan underwriting now. I don't know about the legal ramifications. The functional ramifications are the lenders, going to be looking for it, and I mean that's going to be a box that they're checking in their loan file, and so you're probably going to have a hard time, getting them to close the loan without it. I think they added a requirement that is provided now, but I guess again I would be more focused on the functional ramification, which is the lenders, gonna withhold, loan closing probably until they have a complete file that they can, sign off on.
Yeah, keep in mind the inspection resolution, it says it right there on the form, is an amendment to the contract, and the lender's certainly required to have all the contract. I mean, imagine if you sent the lender the contract and left off the last 4 pages. So it's part of the contract, and so it needs to go to them. Don, with respect to a landlord, can a landlord refuse to rent property to a group of renters? For example, 3 or 4 students or renters that want to rent together. Can a landlord refuse to rent to them?
Sure, that's an interesting question, and actually it comes up fairly often. Landlords have control of protecting their property and making business decisions about who they rent to and who they don't. The issue for a landlord becomes, are they making a decision to not rent to this group based on a protected class of this group? So if you're saying, I don't rent to anyone with children, then you might have an issue. If you're saying, I don't rent to this group because they're a group of individuals that require special assistance, then that could be a problem. But if you're a landlord and you're saying, hey, I don't rent to unmarried people as a business decision, and as an individual property owner, you'd have the right to decide who that you rent your properties to.
And you certainly see this a lot in college towns where people don't want to rent to unrelated parties. In fact, I think in Boulder and Fort Collins, there's actually specific ordinances that no more than a certain number of unrelated people can live in any particular residence.
Right. Mm-hmm.
Yeah. Scott, with respect to inspection reports, a lot of lenders now are asking for these or requiring them. The question we have is how to deal with a new inspection provision that requires the buyer to supply a copy of the inspection report to the lender. Certainly there's no laws that require that, but certain lenders are requiring that as a matter of their policy. Why don't you speak to that a little bit?
Yeah, I mean, it gets back to kind of the last question that I answered. I mean, the lender really controls the deal to a large degree because they're buying in for, in most cases, 80% of it. And so if they're going to ask for a copy of the inspection, I mean, the interest now is securing making sure that they have a good security interest in a quality asset. And so whereas, in years past, and I think it to some degree led to some of the mortgage crisis that we all endured, lenders were very sort of cavalier about, there's no bad investment in real estate or some, silly logic like that. And it led to a very loose underwriting standards, and that all changed, both from the federal government mandating some of that, but also from these are publicly held companies. A lot of these large lenders, or the money is ultimately sourced there, and they want to make sure that they have good investments, and they know that, or they expect that next time they get into a mortgage crisis, the federal government's not going to step in and bail them out. And so they're really crossing their T's and dotting their I's when it comes to having a complete loan package. And if, in their estimation, that should include the inspection report, then I'm not sure functionally how you're going to get around delivering that to them. And if I was the underwriter on a loan, that's a document that I would want to see as well. So I kind of get their position on it.
Yeah, exactly. I mean, the issue there is, the golden rule of he who has the gold, makes the rules. And if you want their money, then you have to play by their rules. And I think this largely came about, as you discussed, as in the past. Inspection may result in a determination that the roof is bad, and the buyer will decide to waive any requirement to get that repaired in their purchase. And then the lender gets involved and makes a loan, and subsequent problems, occur later that they didn't know about, but they could have had they have gotten the inspection report to begin with. So, it's a lender policy, and maybe you can find some lenders that won't require it. Maybe some smaller banks or private lenders. There's obviously ways around that, but if you're going with the big national type of lender, you'll probably run into that every time.
Absolutely. Don, if this deals with inclusions with respect to personal property, if an arm that was holding a TV is attached to the property, would this be an inclusion, or can the seller take this with them?
The arm's attached to the real estate, right?
Correct.
So you're talking about a television that's attached to a wall. So if you have attached the arm to the wall to hold the television, technically it becomes attached to the real estate and becomes part of the real estate. I don't see a lot of landlords that would demand that they keep that television, though, because it can be easily removed without damaging the property, or even the arm that's attached to the wall. If you take that arm off of the wall, I don't see very many landlords that would go running after the tenant, to collect their damages for theft. But if you don't repaint and repair the wall, they certainly would come after that former tenant for the damage that they've caused.
But I think they're looking more lines of a buyer-seller.
Mm-hmm.
So a buyer comes in and sees it
Sorry.
attached, and the seller wants
Right,
to take
right.
it off and take it with them. I agree with you. It becomes a
Absolutely.
fixture. It's once it's attached to the wall. The next question obviously becomes, what about the TV that's attached to the arm, right? Does the TV become a fixture since it's attached to the wall as well?
Yeah, this fixture stuff is, it leads to a lot of disputes, and the answer, I would agree with everything that Don said. I think the same thing kind of applies with the landlord-tenant stuff. I've heard rules that, if it takes a tool to take it off, then it's a fixture. I've heard disputes with respect to gas grills that have been somehow tied down. As an agent in preparing a contract or as consulting your seller client in receiving a contract or countering a contract, you have to be clear. That's the bottom line.
Absolutely.
You want to make sure your inclusions and what's defined as a fixture, what's coming, what's going, or what's staying, what's going, is well defined. Because if it's not, then you're going to set yourself up for that, particularly in this age of, everybody's got a mounted flat screen television, they've got built-in audio video equipment, built-in, hanging speakers, surround sound, the grill stuff. There's so much that are gray areas, and enough that you can avoid the whole thing by just spelling it out accurately in the contract from the inception.
Yeah, and I would agree. I probably get a couple questions a week on this, literally, and I guess I always tell brokers, when you're representing the buyer, if your buyer wants it, then you need to put it in the contract as an inclusion. If the seller doesn't want to give it to you, they'll counter and exclude it. And the same rule applies to a seller. If you're representing a seller and you do the listing, you need to sit down and walk the property with them and determine what it is that they want to take with them and be sure and exclude it. Because I can tell you that when there's a dispute over these things, it always comes back to the broker buying it. And I would agree in the sense that if I've hired Scott to be my broker and we're buying a property and I assume that the TV on the wall goes with the house and for some reason it doesn't or there's a dispute over it, it needs to be in the contract. And I think that's one of the reasons that people hire you, is they hire you for your expertise in drafting the agreement and advising them. And so this is certainly an area that is very easy to deal with, but a lot of brokers get into trouble with it because they don't take the time to look at some specific items that a buyer might want or a seller might want to keep and deal with it in the contract, and it becomes an issue at closing. The craziest one I ever had was a buyer and a seller fighting over whether or not the koi fish were personal property and go with the property or whether they were attached. And the seller was saying, well, how well would they do if we pull them out of the water? And the buyer was saying, they're attached to the water. So just be clear on what's included and what's excluded in the property is really the rule of thumb there. With that, we're out of time. I appreciate all your questions today. And Don and Scott, I certainly appreciate you guys being here today with us and sharing your expertise with our members. And again, if you want to refer this to other people or if you didn't see the whole thing, we record these for you and they're available on our website for viewing. You can also go to our website and see what the schedule is for upcoming webcasts and other things that we have on hand. With that, thank you for being here with us this morning and good luck to you today.
Who wants more peas?
Go away.
Oh, Daddy hates pop-up ads. Who wants
Go
more?
away.
Hashtag dinner time.
Scroll forward.
Choose selfie. No. Selfie.
Go forward.
Delete selfie.
Go away.
Then picture.
Bookmark. Go away.
No, post photo.
Scroll up. Scroll forward.
Hashtag gravy.
The First Bank mobile app. Technology has never been so easy.
And with Uverse, you can move your TV anywhere in the house.
We're happy with Xfinity. Why would we move the TV?
I don't know, but let me show you. Now, if you had the Uverse wireless receiver, you could take this anywhere. See? Anywhere you want.
Don't settle for Uverse. Get the most entertainment on any device anywhere with Xfinity from Comcast.
The first thing is the people. Obviously, this business is about the connections you make and the people you trust. And the most important people that I trust in this industry are at this company.
The new beginning. Other companies are doing things the same way they've always done them. And so having a new opportunity to do things a different way is what really intrigued me.
I'd say from a sales perspective, what I love most is that we have really the best of both worlds. So we're a big multi-billion-dollar international company with great financials. But on the other side, we also feel very much like the small little family-run company.
I like the safety of First American, but they've got a human side to them, you know, a little softer, gentler approach. And I really appreciate that. And they've really given me a great opportunity to go out and try and build something for them.
In Colorado, guess what? We're all local. There's 4 local underwriters, and together the other day we have in almost 125 years of local underwriting experience in Colorado. And I tell that to people all the time, and that's really the big difference. We can make local decisions quickly to get that deal to the closing table. That's the big difference.
We're a team, and we support each other and look out for each other, and it really promotes more business for us.
First American is all about a work-life balance, and the leadership is incredible because they truly care about the customers or the associates that work here.
This is our customer service department, and the marketing support services that are just completely robust. Marketing is a challenge for a lot of real estate brokers. It's something they have to do, but it takes a lot of time. It can be expensive, and we have a fulfillment solution that is far and away better than anything else that our competitors have to offer.
The leadership is very down to earth, and they move very quickly. So anytime I've needed something or had to support a customer or had to make a decision that maybe cost the company money or whatever, they're very quick to make a decision on that stuff.
You're working with people who have been in this market, in the Colorado market, for 30 plus years. At one point, First American was underwriting almost 70% of all transactions in Colorado, and some of those very people were working on those files.
I really believe our people are passionate about our company and do it better.